In recent weeks, the Department of Justice has turned its full attention toward Washington state, and what is happening there should concern not only residents of the Pacific Northwest, but also every single gun owner across the country. On the surface, the fight looks like it is about immigration policy, specifically a 2019 law called the Keep Washington Working Act. But beneath the surface, this case is shaping up to be a precedent-setting battle over whether the federal government can directly force states and local officials into compliance, and that precedent could be used against every Second Amendment sanctuary law in America. Today, we're going to break down what the DOJ is doing, why Washington's law triggered such an aggressive response, how sheriffs are caught in the middle, and most importantly, why gun owners need to pay close attention to a fight that might seem at first to be about immigration, but in reality is about the balance of power between the federal government, the states, and the rights we hold dear. The story begins with the DOJ's ultimatum. They gave Washington's governor just 7 days to dismantle the sanctuary law or face lawsuits, criminal charges against officials, and the loss of federal funding. That is not an idle threat. Federal law enforcement grants account for millions of dollars every year that Washington's police departments rely on for training, equipment, and operational costs. Pulling that money would immediately weaken local law enforcement across the state. But the threats went even further. The DOJ signaled that it was willing to pursue criminal charges not just against the state in general, but against individual sheriffs, mayors, or other officials who enforced the sanctuary law. That alone represents a dramatic escalation because it puts personal liability on the table. No longer is this just a policy dispute between Washington and Washington, D.C., it becomes a matter of individual men and women facing prosecution for following their state's law. To understand why the DOJ feels so strongly, we have to look at the Keep Washington Working Act itself. Passed in 2019, the law barred local police from cooperating with federal immigration enforcement. That meant no detaining individuals for ICE, no immigration checkpoints, and not even passing information along to federal officers. The state argued that the law would make immigrant communities feel safer, encouraging people to call the police without fear of deportation. The problem, however, is that the law went beyond simply choosing not to use state resources. It actively prohibited cooperation. Even if a sheriff wanted to work with federal officers, the law said he could not, and in fact, the state attorney general went so far as to sue Adams County Sheriff Dale Wagner after he continued cooperating with ICE. That lawsuit turned out to be a gift for the DOJ because it provided a perfect case study showing that Washington was not simply stepping back, but was actively blocking federal enforcement. The DOJ's legal argument rests on 8 U.S.C. 1373, a federal statute that prohibits states from blocking information sharing between local officials and federal immigration officers. By telling local police that they cannot communicate with ICE, Washington's law directly violates that statute. And the lawsuit against Sheriff Wagner further demonstrates that the state was not only refusing to assist, but was punishing those who chose to comply with federal law. Courts tend to look unfavorably on state actions that obstruct federal enforcement in such a direct way. The DOJ knows this, and they are pressing hard because if they win, they walk away with a court-tested precedent that they can use again and again. Now, the DOJ could have stopped at words, but instead they backed up their position with heavy threats. They warned of criminal charges against state officials, loss of federal grants, and civil lawsuits that could drag on for years and bleed the state of resources regardless of the outcome. From a strategic perspective, the DOJ does not even need to win on every front. One solid ruling in their favor would be enough. With a precedent in their pocket, they can use it as a weapon to pressure other states in the future. That is why this case matters far beyond immigration. Once the federal government proves it can force compliance here, the same logic will be applied to other sanctuary laws, especially the Second Amendment sanctuary laws that have been adopted in states like Texas, Montana, Arizona, and Idaho. From Washington's side, the governor and attorney general are refusing to back down. They argue that the law simply ensures state resources are not spent on federal civil immigration work. They frame the DOJ's actions as political bullying, but their position is weakened by their own actions against Sheriff Wagner. On the one hand, they claim they are just protecting resources. On the other, they punish a sheriff who chose to cooperate. That contradiction gives the DOJ exactly the ammunition it needs in court. And make no mistake, the DOJ is carefully building its case around these examples. The result is a classic standoff. The state digs in, the feds escalate, and sheriffs are left in the middle, forced to decide whether to obey state law or federal directives. Sheriff Wagner's decision to keep working with ICE against state orders turned him into the face of resistance. For him, it was not about politics, but about doing his job the way he believed it should be done. For that, the state dragged him into court. But he is not alone. He now has support from America First Legal, founded by Stephen Miller, and legal representation from the firm Cooper and Kirk. Together, they are arguing that Washington's law is unconstitutional because it punishes local officials for complying with federal law. That is an argument judges are likely to take seriously, and it ensures this fight will be watched closely across the nation. Why should gun owners care? Because what is happening in Washington is a test case. The DOJ already crushed Missouri's Second Amendment Preservation Act, and now they are looking to reinforce that victory with another ruling. Immigration is the battlefield today, but tomorrow the same playbook can be used against gun sanctuary laws. These laws, passed in conservative states, declare that local law enforcement will not enforce federal gun control measures. If Washington loses this fight, the DOJ will have the precedent it needs to argue that those gun sanctuary laws are illegal too. One win on immigration gives them the legal tools to go after firearms rights across the country. That is the real game. The federal government is not just looking for compliance in one state, it is building a strategy. Once a court agrees that a state cannot block cooperation on immigration, the DOJ can apply that same principle to gun laws. They can walk into court and say, "We already won on this exact issue." Judges rely heavily on precedent, and that is what makes this so dangerous. A ruling against Washington will echo across the nation, providing justification to dismantle gun sanctuary laws from coast to coast. For states that have declared themselves Second Amendment sanctuaries, this should be a wake-up call. Texas, Montana, Arizona, Idaho, your laws are next in line. It is not paranoia, it is how the legal system works. The DOJ does not need to start from scratch in each case. One ruling is enough to build a domino effect. That is why gun owners must pay attention to what is happening in Washington, even if immigration is not their top issue. This fight is about more than immigration. It is about whether states have the authority to tell their local officials not to participate in federal enforcement, whether that involves immigrants or firearms. The larger question here is, who holds the power? Do states have the right to decide how their law enforcement resources are used? Or can the federal government override that decision and punish anyone who resists? The answer will shape not only immigration policy, but also the future of the Second Amendment in America. If the courts side with the DOJ, the message will be clear. When the federal government demands cooperation, states have no choice. That precedent would destroy the foundation of sanctuary laws, whether for immigration or for guns. So as we watch Washington State dig in and prepare for a legal battle with the DOJ, gun owners across the country need to see this for what it is, the opening shots of a much larger war over states' rights and the limits of federal power. The DOJ does not pick fights at random. They choose cases that can set precedent. And with Washington, they see a perfect opportunity. The law is clear. The example of Sheriff Wagner provides strong evidence, and the political optics favor the DOJ. Once they secure a victory, they can turn to other states with the weight of federal precedent on their side. For anyone who values the Second Amendment, the stakes are clear. This is not just about immigrants, not just about Washington state, and not just about one sheriff. It is about building a roadmap for federal enforcement against state-level resistance. If we ignore it, by the time the DOJ turns its focus to gun sanctuary laws, the battle will already be lost. That is why it is critical to pay attention now, understand the strategy being used, and prepare for the fight that is coming. In the end, the fight in Washington will determine more than the fate of one state's immigration law. It will determine whether the federal government can reach into every county, every sheriff's department, and every state house to demand obedience. It will set the precedent for how far Washington, D.C. can go enforcing compliance. And it will almost certainly be used as the blueprint for dismantling state-level protections of gun rights. For gun owners, that makes this case one of the most important battles of 2025, even if it seems at first to be about something else. The DOJ has drawn a line, and Washington state has refused to back down. The outcome will echo across the country, and when it does, every Second Amendment sanctuary state will feel the impact. The question is not whether the DOJ will use this precedent against gun owners, it is when. And that is why, even if you live thousands of miles from Washington, this fight matters to you.